Ah, volontiers.
Excellence,
Excellencies, distinguished delegates, I call to order the 7th plenary session of the 24th session of the Assembly of States Parties on the topic of cooperation. Under the topic, what support can states parties give to the court so that the court can overcome the challenges it's facing? And throughout this plenary, the Assembly will continue to underscore, as every year, the crucial importance of heightened cooperation between states and the court so that it can deliver on its mandate. I'm honored to take part in this first segment of today's plenary with my dear partners. I wish you fruitful discussions, and I want to thank the co-facilitators for cooperation, for their commitment and their ongoing work, Ambassador Bafet from Senegal and Ambassador Alabrune from France. And I'd like to hand over to them now for a few introductory remarks on this most important topic.
Madame la Présidente de l'Assemblée.
Madam President of the Assembly of States Parties, Deputy Prosecutor, dear ambassadors, ladies and gentlemen. Speaking in my own capacity, but also on behalf of my colleague, His Excellency Ambassador for Senegal, Ramatoulaye Bafet, I want to thank you for your words of introduction and thank each and every one of you for taking part in this plenary session on cooperation here at the 24th session of the Assembly of States Parties to the Rome Statute, which actually brings to a close a process that's been ongoing throughout the year 2025. During that time, the Ambassador of Senegal and myself, along with our teams, have been working hard as co-facilitators to promote cooperation between states parties and the court, which, as I think we can all agree, vital for the court to be able to successfully deliver on its mandate. Throughout the year, we have underscored one particular important topic, which is that of arrests. And we've been also focusing on the safety and security of the court and its agents, which is vital for it to do its work. We've also had the occasion to make some presentations on various subjects, such as different forms of cooperation and complementarity, on preventive measures that could avoid escalation to situations of non-cooperation with interventions from our non-cooperation focal points, also voluntary cooperation agreements, and jointly with another facilitation facility, and that is the legal aid facilitators, we've also looked at the issue of financial investigations. The Bureau report, which is available, sets forth the details of all of that work accomplished in 2025. As you know, today's plenary session is being held in a context that is fraught with pressure being exerted against officials of the court and threats of even heavier sanctions against the court itself. The aim of this morning's session is obviously to contribute to greater mobilization on the part of states parties, with the aim of cooperating with the court so as to ensure that it remains resilient, independent, and all of this in the name of the fight against impunity and justice for victims. There'll be two segments to this morning's plenary. There's, first of all, a political segment, which will enable us to hear from the President of the Assembly, President of the Court, the Registrar, Deputy Prosecutor of the Court, who will be calling on states parties to make full use of all of the existing cooperation tools so as to support the court. It will also give us a chance to hear from any delegations who wish to take the floor at that time. And then the second part of our work this morning is of a more technical nature. We'll be looking at more operational aspects on the important issue of arrests. And we shall also be looking into victims, which obviously are at the very heart of the International Criminal Court's mandate, and looking at assistance and reparations for victims, as well as victim and witness resettlement agreements. And now I am happy to hand over to the Ambassador of Senegal, Ramatoulaye, who's going to be chairing this first political segment. Thank you very much, François. Thank you for that very clear introduction, which I think really does set forth where we're headed for this political segment. Madam President of the Assembly, Madam President of the Court, Madam Deputy Prosecutor, dear Registrar, Excellencies, ladies and gentlemen. Now what we're going to do is move through this segment first by hearing from the High Representatives of the Court, and I want to thank them for honoring us with their presence here today. I'm pleased to hand over now to the President of the Assembly of States Parties. Madam President, you have the floor.
Ambassador.
Thank you very much, Madam Baffet. I am pleased to take the floor before you here today. Now, over the last few years, cooperation is no longer just a judicial question. It's actually a strategic pillar of the Rome Statute system.
I would like to take a step back and remember that the Rome Statute created a double nature institution, a court and an international organization. As such, the Assembly of States Parties provides a platform for encouraging all stakeholders to engage into shaping the future of the ICC and to consider further measures to ensure full and effective cooperation with the court. We, the Assembly of State Parties, adopt annual resolutions as legal reaffirmation of our commitment to support the court to fulfill its mandate, holding accountable perpetrators of the most serious crimes of concern to the international community and delivering justice to victims. In this regard, our discussions today are situated within a broader context: the need for support and unity. The court requires not only cooperation in its traditional sense, but also visible and consistent diplomatic backing. When its independence or officials are challenged, responses from states parties can contribute to safeguarding its authority and integrity. In 2025, the court has been facing threats and coercive measures, including the use of sanctions against elected officials, but also against those cooperating with the court, including our partners from civil society organizations. Cooperation has taken an additional and significant dimension, serving as a means for states parties to stand united in reaffirming their full support for the court and the values it upholds. I understand that the Hague Working Group will examine next year interesting issues related to protection, becoming an integral component of the broader concept of cooperation. In that regard, I would like to highlight the growing significance of the Agreement of Privileges and Immunities of the International Criminal Court, currently ratified by 80 states. Its provisions protect the court's assets, funds, and financial independence. It serves as an important framework for the protection of the court and its elected officials, staff of the court, counsel, and persons assisting defense counsel. As we know, effective cooperation entails implementing constitutional and legislative frameworks. It is also facilitated by voluntary cooperation framework agreements. They constitute standard model agreements to support the registry in matching judicial needs. It is important to underline that those framework agreements do not add any international obligation on the state, which remain the only authority to decide upon the cooperation request case by case. Those agreements cover notably enforcement of sentences, witnesses and victims' relocation, interim and final release for accused or acquitted persons. Continued dialogue between capitals The Hague and New York, knowledge sharing and strengthening of cooperation frameworks will prove decisive. The Assembly, through its facilitations, has an important convening role to help states assess gaps, exchange best practices, and collectively respond to challenges. Let us continue working hand in hand, states parties, the court, civil society, and all stakeholders to ensure that cooperation remains not only a duty, but a tangible sign of fight against impunity and solidarity with victims. I thank you.
Merci beaucoup.
Thank you very much, Madam President of the Assembly of States Parties, for that very enriching statement. And now I should like to hand over to Madam President of the Court. Madam President of the Court.
To give you the floor. Before you speak, allow me to congratulate you and commend your recent visit to Dakar, which marks a new step in the long-standing tradition of cooperation between Senegal and the court.
Thank you very much for mentioning about the recent visit to Senegal. Thank you very much. Madam President of the ASP, Excellencies, ladies and gentlemen, I'm very pleased to address this plenary meeting on cooperation and thank the co-chairs, ambassadors, France and Senegal, for their invitation and their steadfast efforts as co-facilitators. Cooperation lies at the heart of the court work. It is through the actions of states that the court can fulfill its mandate. Traditionally, this has meant judicial cooperation, executing arrest warrants, enabling the collection of evidence, and protecting witnesses. Such cooperation remains indispensable to ensuring efficient proceedings. In this regard, I thank Germany and all parties involved in the successful surrender that took place on Monday. Thank you very much. The domestic proceedings that took place prior to the surrender demonstrates Germany's strong commitment to the rule of law. It shows how due process at all levels are essential for the overall fairness of ICC proceedings. And I encourage all states to enact proper legislation that would also allow them to cooperate with the court in similar situations. As the court faces new challenges, it requires us to readjust the focus when we discuss cooperation And today's plenary is a perfect occasion to discuss where the focus should now be. Indeed, cooperation is all the actions of states that ensure the proper functioning of the court. Protecting the court against coercive measures allows the court to fulfill its mandate, and it guarantees that the court's independence and effectiveness are preserved. It is therefore a core component of cooperation. The obligation to guarantee the court's independence is rooted in Article 48 of the Rome Statute and is reinforced. We are ratified by the agreement on the privileges and immunities of the ICC, APIC or APIC, as well as by the headquarters agreement with the host state. Article 48 specifies in particular that privileges and immunities extend to judges, the prosecutor and his deputies, the registrar and court staff, as well as any person required at the seat of the court. The APIC further extends these protections across the territories of all ratifying states. As some elected officials, including myself, are subject to arrest warrants because of their work, guaranteeing privileges and immunities is crucial. Furthermore, in the context of coercive measures and their potential financial implications, the APIC provides crucial protections, including safeguarding the court's funds, property, and assets from interference, search or seizure, and ensuring the inviolability of its documents and communications. As pressures on the court and its personnel increase, these guarantees are essential for ensuring that the court can operate independently and effectively. The APIC is crucial to the court's ability to deliver justice for victims of the gravest crimes. I therefore reiterate my call for all states to ratify and implement the APIC. Since the last ASP, one state acceded to the APIC, and I would like to congratulate Timor-Leste for taking this important step. Yet, 45 state parties have not done so. I encourage them to begin the process, as the APIC provides vital safeguards to the court's independence and integrity of its proceedings. Excellencies, ladies and gentlemen, political and diplomatic support is also a way to protect the court and to guarantee that it can deliver on its mandate. When state parties are united in defense of the court through joint statements, for instance, but also behind closed doors, they also reinforce the court and their commitment to the court's mandate. I am very grateful for your leadership in that regard, Madam President, and for the support from this Assembly, from the state parties, and for the commitment from all the organizations and actors who support the court, support the work of the court. Thank you for your attention. Thank you very much.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Now I should like to hand over to Madam Deputy Prosecutor. You have the floor. Thank you very much.
Madam President of the Court, Mr. Registrar, Their Excellencies, the Ambassadors of France and Senegal, distinguished delegates and colleagues. It's a pleasure to participate in this plenary session addressing the core area of activity on which the success of our investigations and prosecutions depend, cooperation. Allow me firstly to express my sincere thanks to France and Senegal as organizers of this session and as ASP co-facilitators on cooperation. We have sincerely appreciated your partnership in the last year across all sessions of co-facilitation. As Deputy Prosecutor Niang noted in his opening remarks to the Assembly, this has certainly been a challenging year. But it is in fact amidst those challenges, forced perhaps by the coercive environment that we are now operating in, that we have seen significant innovation and therefore progress in our cooperation activities with all stakeholders. By seeking to think differently and to introduce new mechanisms for dialogue, our office has been able to reinforce its capacities and deepen its cooperation with state parties, regional and international partners, and with civil society organizations. These innovations and the new ground we have broken in 2025 represent an implementation of the clear vision that we laid out last year in our policy on complementarity and cooperation. At a time when strong cooperation and spirit of partnership from national authorities is needed by the Office of the Prosecutor and the Court more broadly, more than ever before, it is essential that we also demonstrate an ability to reciprocate, to deliver practical, immediate dividends for cooperation partners that want to invest in our relationship. The key cooperation developments achieved this year have reflected our focus and determination in delivering this vision of mutual exchange and learning, and ultimately delivering increased collective impact. Let me turn to arrest. Innovations in our cooperation and analytical work have enabled concrete results in the field of tracking, and through excellent cooperation with our registry colleagues, the arrest and surrender of suspects to the court. The further embedding of the work of the Office's Tracking and Information Fusion Section, or TIFS, in this area has shown a clear and immediate positive impact in our work, also allowing us to more effectively leverage the support of external stakeholders who have contributed significantly to these activities. It is also important to recognize that for every arrest secured this year, we can point to the painstaking and often delicate and efficient engagement of our international cooperation advisors, who are embedded in the Office's unified teams with relevant national authorities who have both established the relationships that we need to create the conditions for arrest and who have also contributed to these concrete results. This year also, renewed efforts have been made to extend our work with states to ensure the security and the provision of proper care to witnesses who have so often already experienced deeply challenging situations. It is essential for the success of the Office's investigations and prosecutions that we collectively focus on the issue of witness security as a cooperation priority. Our Office's specialized colleagues in this area are crucial in ensuring effective collaboration with external partners on witness security-related matters. The international cooperation advisors within the teams, jointly with our Witness Security Unit and in close coordination with the Witness Security and Protection Unit of the Registry, are developing new strategies aimed at deepening partnerships in different regions of the world. One important platform in this regard is the Office's Complementarity and Cooperation Forum, which facilitates regular expert exchanges in a number of thematic areas, including witness security. Madam President, Excellencies, this area and this year was also key in revitalizing efforts on financial investigations through the establishment of a dedicated financial investigations unit. Financial investigations have always been an important element of our work, but the establishment of a dedicated unit to consolidate expertise, enables the consistent provision of critical insights to strengthen the Office's investigative capacity, and helps financial inquiries complement core investigative strategies. With this new architecture in place, the Office is now looking to identify how this can be leveraged to expand our networks and experience in this area. In this effort too, we need your help. We were delighted that in October this year, within the framework of the Complementarity and Cooperation Forum, the Office was able to welcome over 60 national partners to engage in a discussion on how we can enhance collaboration in this field of financial investigations. We hope that this is just the start. In the coming months, we would like to work with states, civil society, and international and regional partners to implement a modern, dynamic cooperation strategy in this field. And we look forward to continuing this dialogue after this ASP. The engagement and support of our international and regional partners have also been crucial in this period, and the Office has been heavily involved in numerous initiatives to further strengthen this cooperation. We have seen real steps forward in this work, and examples include the hosting of the first Europol Day at the Office to consolidate cooperation and identify further avenues for collaboration, our continued engagement with Eurojust, including in the context of the joint investigation team in Ukraine, our enhanced work with Interpol, as reflected in our participation in a dedicated seminar in Lyon to identify new opportunities for collaboration, and our extensive collaboration with UN investigative entities across these two situations. This area of cooperation will remain a key area of focus in 2026, together with an emphasis on reinvigorating our collaboration with other regional networks in the African, Asian, Middle East, and North African, as well as Latin American regions. Madam Presidents, Excellencies, from this brief review of our landscape of cooperation, we can see that there is a real sense of dynamism in our engagement with all partners. We truly appreciate that our sense of urgency, particularly in this moment, has been met in kind by your provision of rapid and meaningful support. Thank you for the opportunity to speak with you and to address both what we have achieved together in the last year and what we must prioritize again together in the coming year. The Office stands ready to work with you and to find new innovative ways so as to ensure that we can collectively deliver on the mandate set for us by you, the states parties of the Rome Statute. Thank you. I look forward to the rest of this discussion today.
Merci beaucoup, Madame la
Thank you very much, Deputy Prosecutor. Now it's time for us to hear from dear Osvaldo, the Registrar of the Court. The floor is yours. Thank you very much. Madam President of the Assembly of States Parties, Your Excellency Barfay, Ambassador of Senegal, Your Excellency Mr. Alabrune, Ambassador of France, Madam President of the ICC, Deputy Prosecutor of the ICC, Excellencies, ladies and gentlemen, it's an honor for me to address you here at this special plenary session on cooperation. I wanted to express my deep gratitude to the Presidency of the Assembly, as well as to the co-facilitators for cooperation on all of the work that they've done in preparing this space for deliberations. The theme that we're looking into today, how to strengthen our support of the court, has never been more crucial. The threats, the coercive measures, and the sanctions that have been leveled at the court, its staff, and its partners, including from civil society, are not just theoretical threats. They've actually become an operational reality on a day-to-day basis. As the President of the Court mentioned, we're meeting at a time when the traditional understanding of cooperation is now insufficient. In the current context, the court's operational environment needs to be sufficiently protected so that heightened and diversified cooperation can become a reality so that the court can meaningfully and efficaciously deliver on its mandate. And that's why we've come up with the concept of protection as cooperation. Now, let's just be clear. Protection as cooperation is not some additional obligation on states. It's a strategic complement to the cooperation obligations incumbent on states parties that have always underpinned the Rome Statute. The threats and coercive measures are targeting the court's operational vital lines. When banks close their accounts, when insurers flinch and waver, when technological suppliers fear sanctions, the independence of the court is jeopardized. Not by legal argument, by operational strangulation. And the same is true for any stakeholders affected by these measures, including our civil society partners. Protection as cooperation therefore calls up one simple question, that is, how can we guarantee that no external actor, be it a state or a private enterprise, hinder the action of the court as by exerting pressure on the systems on which we depend? So allow me to outline 4 areas where coordinated action is crucial. Firstly, let's address institutional and judicial protections that could be established. States can enhance resilience by, firstly, fully domesticating the APIC, the Accord on Privileges and Immunities. Secondly, by adopting regional or national guarantees that could block the application of the external coercive measures. And thirdly, by delivering formal assurances that these unilateral sanctions shall not have primacy over conventional obligations. And these aren't just symbolic measures. They can actually serve as a rampart for the court as it continues to work without intimidation. Secondly, how to ensure the court's financial continuity. The court's ability to operate depends on secure banking and payment systems. And here, states can play a decisive role. Firstly, by paying their assessed contributions early. Secondly, by ensuring that national banks maintain their services to the court. And thirdly, by supporting payment infrastructure that could be out of reach of these coercive measures. A third area is one where we've actually already made some progress towards independence, and that is technological and operational resilience of the court. If we want to guarantee the court's IT independence, then states and the IT independence of the court, states, and regional organizations, then what needs to happen is firstly that the court can be integrated into national cyber defense support, that sovereign hosting of regional cloud solutions could go ahead, and thirdly, that airlines, telecoms providers, and political orientations could be put forward that would maintain commercial relations with the court. And fourth domain, political and diplomatic protection. And here we need to hear a unilateral, a unanimous call on the part of states parties so as to ensure judicial independence. We need to dissuade all of these coercive measures, and these would ensure the protection and resilience of the court because not only is that vital for the court, but the diplomatic and political engagement is actually a really robust response on the part of states parties. Excellencies, the essence of protection as cooperation is very simple. The court can only fulfill its mandate if the financial, operational, institutional foundations are defended sustainably. And this means that we're going to need coordination between the courts, states parties, and regional organizations and our partner international institutions. Before I conclude my remarks, allow me first of all to share with you a few positive developments in the field of cooperation between the court and states parties. On the 1st of December of this year, Mr. Khalid Mohammed Ali Al-Ashri was surrendered to the ICC after having been arrested by the authorities of the Federal Republic of Germany and on the 16th of July, and this was in accordance with the ICC arrest warrant issued, and we thank them for that. And this success is part of our broader efforts here at the court to guarantee arrest and surrender of suspects that are sought, and the rollout of our recommendations for heightened commitment between from states parties on executing arrest warrants. Adopted in September of this year, have been presented by the co-facilitators on cooperation, France and Senegal, to the states parties, and it really is advancing well. The registry, in cooperation with the OTP, will continue to build on these efforts, and we're delighted to have further exchanges with states parties on those recommendations. Thank you.
Merci beaucoup, cher.
Thank you so much, dear Osvaldo. At this stage of our work, I would like now to give the floor to delegations and others who would like to speak and share their expectations or support to the court.
Donc, sans plus tarder.
Without further ado,
Effectivement, ça c'est très important de.
yes, it's very important to mention the following. I just wanted to emphasize that the amount of time, floor time, will be 2 minutes for upcoming speakers. So, without further ado, I invite Ms. Karen Blackstone, advisor of the Ministry of Justice and Security of the Kingdom of the Netherlands.
Okay. Thank you very much for giving me the floor. Dear Excellencies, dear colleagues, we have come together at this ASP while the court is facing serious challenges and interference. It is our joint responsibility to ensure that the court remains resilient and can continue its day-to-day operations unhindered in the face of these challenges. It is at times like these that cooperation in all its forms is essential to keep the ICC not only functioning, but enabling it to fully and effectively deliver on its mandate. After all, Chapter 9 is the cornerstone of supporting the investigations and trials of the court. We continue to urge all states parties to strengthen their commitment in relation to voluntary cooperation agreements, be that for the protection of witnesses, interim release, or the enforcement of sentences. The court requires support from all of us, especially with the upcoming conclusion in several trials. We therefore welcome the voluntary cooperation agreements signed by Latvia and Lithuania this year. We also encourage states parties that already provide voluntary cooperation to share their implementation legislation and best practices with other interested states parties. As host state, we continue to play our part in supporting the court's work by facilitating detention, transfer of detainees, the entry of witnesses, and supporting the security of the court's premises. From the perspective of complementarity, it is of key importance to continue to improve cooperation between states. Conventions such as the Ljubljana The Hague Convention on International Cooperation are a vital tool to combat impunity for the core international crimes in support of victims across borders and to ease the burden on the court. In this regard, we welcome the first ratification of the convention by Latvia. We urge other states parties to consider ratifying the convention as well and stand ready to offer our assistance where needed. I thank you.
Thank you for your contribution. À présent, je vais donner la.
At this stage, I will give the floor to the distinguished delegate from Mexico.
Co-facilitadores.
I'd like distinguished co-facilitators. Cooperation is the foundation which allows the court to accomplish its mission. Without effective mechanisms and the commitment of state parties, the system of the Rome Statute does not have any response capacity. Therefore, the support of all is necessary to bridge the gap of cooperation. We exhort all countries to operate in good faith with their obligations regarding cooperation. And this includes the execution of the 33 arrest and surrender warrants that have been produced by the court, which will strengthen its credibility, effectiveness, and especially justice for victims. The resolutions that this Assembly shall adopt will emphasize that cooperation needs to base itself on institutional and legal frameworks that are solid at a national level. It's not only a matter of supporting the statute. We need strong procedures and real commitments from states to respond promptly to cooperation requests stemming from the court. Cooperation also implies supporting on the operation side to execute on legal decisions and guarantee the safety of both witnesses and victims through voluntary agreements that support technical exchanges and coordination between the prosecutor's office, the secretariat, and national authorities. Similarly, keeping in mind the current context, we want to emphasize that resolutions include protection as a part of cooperation, as they recognize that by protecting the court, its staff, and those who work with it in the face of threats, pressures, or other interference is in and of itself an act of cooperation. With that backdrop, we invite for all to ratify the agreement on immunities and privileges of the ICC so that staff and judges and all involved can carry out their work without intimidation. International cooperation has a broader dimension which includes multilateral organizations. The recent experience we've seen in Darfur, Sudan, with the first sanction from a case stemming from the Security Council shows how working with the United Nations can generate concrete results. Similarly, cooperation with Interpol, Europol, Eurojust, and other mechanisms remain essential for investigations, the protection of individuals, and the effectiveness of the system writ large. Esteemed colleagues, cooperation is a collective responsibility and is necessary to uphold truth, justice, and reparations for victims of the gravest of crimes. Its effectiveness requires pooling efforts to maintain and uphold our commitment to the statute. Today, Mexico reaffirms its disposition to continue work with the court and to contribute to the effective work of the system of the Rome Statute with a view to translating promises into concrete results. Thank you very much.
Merci beaucoup.
Thank you very much. I'd like to give the floor now to the representative from the United Kingdom and Northern Ireland.
The floor. And good morning, distinguished delegates, colleagues and friends. On behalf of the Government of the United Kingdom, I would firstly like to thank the co-facilitators for cooperation, Ambassador Francois Alabrun and Ambassador Ramatoulaye Bafé, for their dedication to this important topic this year. The United Kingdom is committed to upholding international law and holding those who commit the most serious crimes accountable for their actions. We recognise that state-party cooperation forms the backbone of the Rome Statute system. The ICC could not function to its fullest extent without it. At a time where the court faces unprecedented challenges, never has cooperation been more important. Throughout 2025, the cooperation facilitation has covered the breadth of cooperation matters and has demonstrated the commendable progress that has been made in sharing information and best practice. We will continue to actively engage in this important work, including where it is helpful to do so across working groups. The United Kingdom was pleased to be invited by the Registry and facilitators to share our reflections and experiences regarding requests for arrest and surrender during the second facilitation meeting this year. We welcome the development of practical and effective channels of communication between the United Kingdom and the relevant court organs in relation to cooperation. We encourage other states parties to similarly engage with the court. However, amidst the positive work on fostering cooperation, the United Kingdom notes the concerning rise in non-cooperation proceedings, and encourages state parties to consult early and in good faith with the court where they identify obstacles to execution of a request from the court. Finally, we would reiterate our call on states parties to give full effect to the court's cooperation agreements, including the agreement on privileges and immunities. We call again for those state parties who have not yet ratified the agreement to do so, to ensure the court has the support it needs. The fight against impunity demands our collective best efforts to ensure effective collaboration and cooperation is at the heart of each state party's relationship with the court. Thank you.
Merci beaucoup.
Many thanks. At this stage, I'd like to give the floor to Ambassador Arnaldo Brenes Castro, the Ambassador of Costa Rica. Madam President, distinguished representatives of the bodies of the court, distinguished delegates. Cooperation is the cornerstone of the effectiveness of the ICC. That is how it was established in the Rome Statute under Part 9 and is confirmed by the Strategic Plan for the ICC 2026-2029, specifically under Strategic Goal number 4, strengthening cooperation. Without full cooperation, the goal to offer justice to victims and guarantee accountability cannot be accomplished. Today, our responsibility is more pressing than ever. There are arrest warrants pending, and their execution depends completely on the commitment of states. The fight against impunity and the protection of human rights is not an abstract aspiration or dream. It requires concrete actions, especially when it comes to executing arrest warrants, access to proof and evidence, financial cooperation, freezing and confiscation of goods, and the support to all the bodies of the court. Cooperation also takes shapes that go above and beyond the strictly legal obligations. We're talking about voluntary cooperation, acceptance of witnesses and protection, taking care of people under limited freedom, and operational support. It is these legal support systems that allow and give life to the system that's been active for a quarter century. In the face of increasing threats and coercive measures against staff of the court, it's indispensable that state parties defend its independence, safety, privileges, and immunities. To attack those who build day-by-day international justice is to erode the very foundations of an essential system for humanity. It is therefore essential that all state parties adopt the agreement on privileges and immunities and take the necessary measures to protect elected officials. Madam President, accountability for the gravest of crimes needs to go beyond ideologies, identities, and any alliances. The pain of victims, regardless of where they come from, is universal, and it requires an equally universal response. The Nuremberg principles remind us that no person, regardless of their role or nationality, is above the law. Costa Rica reaffirms today its commitment to the court. We appeal to state parties to cooperate consistently under all situations without any sort of double standards. If we act together, we'll be able to send perpetrators an unequivocal message that justice shall prevail, and we will give victims the certainty that their voices are guiding our decisions. Thank you very much.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Ambassador. I just want to remind speakers that the allotted time is 2 minutes per statement. At this stage, I'm going to give the floor to Mr. Claudio Trosso Repeto, Legal Director of the Ministry of Foreign Affairs of Chile. Many thanks, Madam President and co-facilitators. Chile reaffirms its support to the ICC and the Rome Statute, essential pillars for the fight against impunity. Since its creation, the court has represented a milestone in the protection of human rights, but it is facing growing challenges, increasing pressures and attacks that try to limit its independent work. These realities not only affect the institution, but they especially affect the victims that await justice. The cooperation of states is absolutely essential for the court to live up to its mission. Without full cooperation, the court will not be able to investigate properly, protect witnesses, or execute on arrest warrants. Many of them remain pending. In this context, we want to celebrate the recent surrender of a party from Germany with respect to the Libyan investigation. Chile reaffirms its commitment to its international obligations and with the strengthening of national cooperation mechanisms. We've included in our national legislation the most severe crimes of international law, and currently it's presented to Parliament for approval. Draft legislation that will strengthen cooperation with the court, allowing us to respond with greater efficiency and speed to its requests. Similarly, we consider that's absolutely essential to protect the independence and safety of the staff of the court. We condemn firmly any form of intimidation, unilateral sanctions, or coercive measures that go against the spirit of the Rome Statute. State parties need to act with determination to make sure that the privileges and immunities of the court are fully respected. Thus it is that we want to emphasize the importance of moving forward in the implementation of the agreement on privileges and immunities and strengthening the headquarters agreement, essential components if we are to guarantee the institutional resilience of the court in the face of external pressures. Lastly, we support the recommendation of the court to protect former staff and officials in the face of coercive measures, and we're grateful for the conceptual note about protection as a form of cooperation that gives concrete guidelines to protect its independence. Madam President, for Chile, cooperation with the court is the operational foundation for the Rome Statute. Without genuine and sustained commitment, we will not be able to make sure international justice makes progress. Thank you.
Merci pour votre...
Thank you for that statement. I'll give the floor now to the delegate of Switzerland.
Mesdames et Messieurs, Excellences.
Excellencies, esteemed delegates, I'd like to thank the co-facilitators for this important work, the Ambassador of France and the Ambassador from Senegal, for their commitment and excellent cooperation that's been very committed with the work of state parties.
And remains vital. The court cannot function without us states parties as its only enforcement mechanism. Without the cooperation of states parties, the ICC is a judicial body without teeth. Switzerland therefore remains firmly committed to cooperate and stands with the court. It is our primary responsibility to support the court's efforts to discharge the mandate we have given it, while respecting its full independence, impartiality, and integrity. We must reinforce our political and operational support to the court to strengthen its resilience against any attempts of interference and intimidation. I would like to underline 2 points on cooperation. First, cooperation contributes to the realization of the rights of victims. It is our shared responsibility to ensure their rights to truth, justice, and to reparation. The Trust Fund for Victims plays a crucial role in this regard. It responds to the particular needs of victims. It enables them to regain their place within their communities and to rebuild sustainable livelihoods. The Trust Fund represents the very essence of all cooperation. Switzerland has been a long-standing contributor to the fund and encourages all state parties to do the same. Second, We would like to underline the practical importance of the agreement on the privileges and immunities of the ICC. We encourage all states parties to ratify this agreement, guaranteeing that court and its officials benefit from the legal protections necessary to operate impartially and without undue interference for the fulfilling of the mandate we states parties have given to the court. I thank you.
Merci beaucoup.
Thank you. At this stage, I'd like to give the floor to the Ambassador Olivier Ben, representative of Belgium here in the Netherlands.
Ça fonctionne? Oui. Merci, Madame la Présidente.
Thank you, Madam President. Let's remember that the ICC is an impartial and independent legal body and can only work on the basis of support provided by states. The court is now facing a multitude of challenges, obstacles to international justice. Sometimes they're due to the behavior of non-state actors that are not part of the Rome Statute, especially in recent times, where might overrides might in many contexts of international relations. In these complicated times, all state parties to the Rome Statute need to work together to support the court, because there is no peace without justice, and no justice without proper legal reparations. Let's move from words to actions. It's high time that each and every one of us have a legislation for effective and proper cooperation and tools for cooperation, such as, for example, a central cooperation authority or contact points to that end, or strengthened cooperation agreements. All these are tools that need to work together and work together with political and diplomatic support that has a backbone and supports the court. Belgium has set up new tools to assure proper cooperation with the court. We are ready to do even more if the court deems it useful, and we're always inclined to make ourselves available to other state parties to provide information on our best practices and exchange experiences. To conclude, allow me to repeat, above and beyond good intentions, it's on actions that we need to focus ourselves today. Thank you.
Merci beaucoup, Monsieur l'Ambassadeur.
Thank you, Mr. Ambassador. And now I'd like to give the floor to the representative of Colombia.
Señora Presidenta, distinguidos delegados.
Madam President, distinguished delegates, Colombia would like to lend its support to the court. Cooperation is vital if we are going to ensure that the court can restore justice and ensure human dignity. We want to reiterate our firm commitment to the court and the commitments undertaken under the Rome Statute, and that and cooperation is key to that. As a state party, we understand that cooperation is not just a one-off. It's an ongoing process that is going to ensure institutional continuity for the court. In recent years, Colombia undertook steps to ensure that its judicial and legal framework is better attuned to its Rome Statute obligations. We are also pleased to see the development in terms of the maturity of our institutions, and this is all part of our complementarity under the Rome Statute. However, it is true that there are ongoing challenges concerning responsibility, accountability, and transparency. Among them, operational difficulties that we have seen when it comes to enacting some of these instruments, and also protection of victims and witnesses. Colombia is undertaking internal assessments to ensure that its legal framework and its roadmap for making improvements to the legal wherewithal be ensured. As concerns protection and security of victims and witnesses, we understand the importance of undertaking measures to ensure that legal protection for victims and witnesses be ensured by the court. And here again, we lend our support. We are currently looking at more appropriate measures so as to ensure the technical wherewithal for ensuring the domestic measures for the protection and security of witnesses and victims. Colombia understands that victims are not just an accessory component. They are a key part of the mandate of this court. And that is why we understand that I'm going to ask you to kindly conclude, sir. Colombia is continuing to work in a spirit of competition on technical issues as well as political issues in the fight against impunity. Our commitment to this fight remains as firm as ever, and we are looking forward to the continued discussions on cooperation. Thank you very much.
Merci beaucoup.
Thank you very much. Now I should like to give the floor to Lawyers' Rights Watch, Canada.
Madam Vice President, Excellencies, distinguished delegates, it is my honor to address you on behalf of Lawyers' Rights Watch, Canada. Ending impunity for atrocity crimes requires actions. Words are not enough. The Rome Statute requires all states parties to fully cooperate with the ICC in the fulfillment of its provisions. Cooperation entails effective political, diplomatic, and legal measures to safeguard the court from coercion. This year has seen unprecedented attacks against the court, including unlawful sanctions by the United States against ICC judges and officials, a UN Special Procedures mandate holder, and 3 Palestinian NGOs, human rights NGOs. Victims of atrocity crimes rely on civil society, including lawyers and human rights defenders, to transform their stories into evidence for transmission to the court. Silencing civil society organizations that cooperate with the court effectively silences the voices of victims calling out for justice and remedies. Cooperation with the court requires states to create secure and enabling environments for civil society. The current pattern of threats and attacks against the ICC comprises an unparalleled threat to the rule of law. To end impunity for the atrocity crimes set out in the Rome Statute, states parties must go beyond supportive words and take firm action. We call on all states parties to cooperate collectively to denounce and urge rescission of the U.S. unlawful sanctions and any other threats or attacks against the ICC, its personnel, or those cooperating with the court. To adopt laws to block the effects of unlawful sanctions, to ratify the agreement on privileges and immunities of the ICC, and to adopt laws to protect human rights defenders. Thank you, Madam Vice President.
Merci beaucoup.
Thank you very much. Now, I should just like to recall to all of those who've just added their names to the speakers list for this first segment that unfortunately we have run out of time, but we do intend to give you the floor in the second segment of this morning's plenary. So without any further ado, I should like to conclude this first segment. I wanted, dear colleagues, to address my most sincere thanks to all of the ICC's heads of organ here for having taken part in this morning's segment, underscoring that cooperation is crucial for the court. I want to thank all of the representatives of states, parties, and civil society for all of their commitment when it comes to cooperation, and for determining avenues for the way forward, which is as crucial as ever. Your statements quite rightly recalled that cooperation is one of the pillars of the Rome Statute, and particularly in a context in which coercive measures are being leveled at the court, aiming some of their its elected officials. This institution will only be efficacious and effective if we as states parties continue to work together, but also non-states parties, international organizations, be they global, regional, or sub-regional, continue to lend support. So with this brings our first segment of this morning's plenary to a close. I'm just going to ask you to bear with us for a few moments so that we can thank our panelists and kindly allow us to reshuffle the seating so that we can get into the second segment, and then we'll be able to hand over to my co-facilitator, Ambassador Lebrun.
Voilà, je vous...
Very well. I should like to invite you all to start the second segment with me on how states parties can offer greater support to the court to meet the current challenges, which is the more technical aspect of this morning's plenary. And we shall, in this segment, be looking at three key subjects. First, arrests, which, as I said a moment ago, is something that we discuss practically every facilitation meeting because it's such an important issue for the court's judicial activity. Secondly, we shall be looking at the issue of victim support and reparation. And finally, the relocation or resettlement of victims and witnesses. So let us get started then with arrests. And in this regard, I'm delighted to offer the floor to two representatives of very committed states on this issue. I will be starting with Ms. Wiebke Ruckert, who is the Deputy Director of Legal Affairs at the German Ministry of Foreign Affairs. And as we heard earlier from the President of the Court, Germany recently showed its dedication and efficacy with the surrender of El-Hishri, so we want to thank Germany for that, and we'll hand over to Madame Ruckert in a moment, and she's going to be followed by Mr. Olivier Christin from France's National Anti-Terrorist Prosecution Unit.
Merci beaucoup.
Thank you.
Excellencies, dear colleagues, I would first like to thank the co-facilitators for cooperation, for their dedication to this topic, and for setting up this very important plenary debate today that we have on all aspects of cooperation in which we as states parties can support the court. I would like to take this opportunity to share our very recent experience in handling a concrete request for arrest and surrender under Article 91 of the statute. And as ICC President Akane kindly mentioned in her intervention at the beginning of this session, and as ICC Registrar mentioned, other colleagues have also referred to it, and you just have, so thank you for that. On Monday, Germany surrendered the Libyan national Mr. El-Hishri to the court. Mr. El-Hishri was arrested on 16 July 2025 in Germany by our national authorities pursuant to a request for provisional arrest issued by the court. It was the first time that our national authorities executed an arrest on the basis of our federal legislative framework for cooperation with the ICC. It was the first time that the provisions on arrest and surrender in our national code or act on international cooperation with the International Criminal Court of 2002 were applied in a concrete case. Procedurally, our legal framework stipulates the following steps. First, after the arrest on the basis of the request of the ICC, the individual must be brought before a judge at the nearest local court without delay. This procedure was followed. Second, upon receipt of a full request for arrest and surrender, the competent higher regional court is called to decide on the permissibility of the surrender. The higher regional court of Brandenburg took this permissibility decision in August. In the present case, Mr. El-Hishri then twice attempted to appeal the decisions relating to his arrest and impending surrender. These appeals were both subsequently declared to be inadmissible by the competent higher regional court of the state of Brandenburg. Both decisions were then tried to appeal to the Federal Court of Justice, and the Federal Court of Justice later confirmed both these decisions as well. In each instance, the national courts confirmed the limited scope of review that German courts are entitled to apply with regard to the arrest according to Article 59 and Part 9 of the Rome Statute, as well as according to our corresponding implementing domestic legislation. By finding the suspect's appeals to be inadmissible, the courts thus confirmed the general principle that the review of ICC arrest warrants falls substantially within the purview of the ICC and not of the courts of the custodial state. Following the dismissal of these appeals, Germany then authorized the surrender of Mr. El-Hishri to the ICC. The successful transfer of Mr. El-Hishri to the custody of the ICC is closely tied to and dependent upon effective and trusting cooperation of the ICC with several German authorities, both on the federal and on the state level. The Federal Office of Justice, the Federal Ministry of Justice and Consumer Protection, the Federal Ministry of the Interior, the Federal Foreign Office, and our embassy here in The Hague, as well as the competent judicial and police authorities, both at the federal level and of the regional states, were involved. I wish to extend our special appreciation to the Registrar of the ICC and to the Registry's Judicial Cooperation and Support Section for their excellent preparatory and supporting work throughout the entire process. As many of you may be aware, Mr. El-Hishri had his initial appearance before the pre-trial chamber yesterday. Some of us here attended it. We are proud that we could contribute to this case moving forward in the court, and we will continue to follow it closely. We remain committed to ensuring accountability and strengthening the system of the Rome Statute. For that, it is crucial that states parties actively support and cooperate with the court, and this debate today, I hope, will contribute to that. Thank you.
Un grand merci.
Thank you very, very much. And again, our gratitude for not only for your presentation today, but also for that arrest. And now I should like to hand over to Olivier Christin, who is the National Anti-Terrorism Prosecutor. Over to you, sir.
Madam Ambassador, Mr. Ambassador, Ambassadors, ladies and gentlemen. It's an honor for me to speak today during this plenary session dealing with cooperation. France has always been committed to work closely with the ICC to repress international crime. We are complementary interactions, and that's always been at the heart of our criminal enforcement policy. As a national prosecutor against terrorism, I value highly our cooperation that's in existence for over 20 years between the court and France. This fruitful cooperation will have to continue for the ICC to work legitimately and with complete independence and continue to judge the gravest of crimes which affect the entirety of humankind. We are aware of critiques, attacks, and coercive measures that now weigh on the court's work. Therefore, we'd like to remind us all that our support to the magistrates of the court and our colleague Nicolas Guillot, a French judge at the ICC, are supported. They're currently under the weight of heavy sanctions, some of them due to arrest warrants issued against leaders of Israel and Hamas, others related to the review of Afghanistan. Removing these obstacles to ICC is an imperative. International criminal law, which is important to all of us here, requires it. It's a duty that for the international community. As a national authority and prosecutor, our support to the work of the ICC will continue going forward with our strengthened cooperation and effective complementarity. Thus it is that the issue of the support to the execution of arrest warrants and surrender of fugitives is at the heart of our work to make sure that the court can carry out prosecutions effectively against targeted individuals of targets of arrest warrants. To renounce this, it would be equivalent to guaranteeing the impunity of authors. The French authorities that execute on warrants are therefore active and mobilized to facilitate the location of suspects on our territory and to provide all the necessary operational support to these operations. These operations, obviously, are done on the basis of strong cooperation between the ICC and all state parties. Thus it is that France contributed notably in 2018 to the location, arrest in France, and surrender of Patrice Edouard Nsona, a suspect in the framework of the investigation regarding crimes against humanity and war crimes in Central African Republic. This is an area of investigation in which reciprocity and cooperation between our offices and the ICC was highlighted on many occasions, allowing significant progress to be made in our respective investigations. These elements remind us of the importance of ever stronger cooperation when it comes to finding suspects to ensure their arrest and therefore to be able to hold trials so that justice can be rendered to victims. The challenges that the ICC faces today are huge, and national jurisdictions and international ones may be appealed on to intervene, and they need to do this in a necessary complementary manner. This strengthened cooperation has therefore allowed for the joint arrest in France and in Germany in February 2019 of 3 former members of the Syrian security services suspected of torture and crimes against humanity after setting up a joint investigation unit between the two countries. After these arrests, 2 were sentenced for crimes against humanity and found guilty. Furthermore, in May 2020, France played a key role in the arrest of Félicien Kabiga, one of the last fugitives for his role in the genocide of Tutsis in Rwanda in 1994. Arrested in Paris after decades on the loose, he was included thanks to our international residual mechanism for criminal tribunals. And here I want to emphasize the work of our specialized unit and the Central Office for Combating Core International Crimes that in their mandate managed to prosecute and arrest criminals that are being searched for by international criminal structures, international criminal justice structures. France and our anti-terrorist prosecutor unit will continue to work to guarantee justice, committing itself to finding criminals, authors of mass crimes in Syria, pursuant to orders of the regime of Bashar al-Assad. This is being supported by the center I mentioned earlier, Europol, and other pertinent bodies. So we have 22 arrest warrants covering 17 high Syrian officials, amongst them including Bashar al-Assad, that have been issued by our unit and French judges. Important cooperation has been set up to allow for their execution. These procedures could therefore lead to, in France, in absentia trials and these suspects could be arrested and surrendered to France. To conclude, I'd like to remind us all that the verdicts that are handed down in coming years when it comes to international crimes will, more than ever, be the result of our collective efforts and our constant commitment to work side by side with the court when it comes to trying the authors of the most severe crimes. Thank you.
Merci beaucoup, Monsieur le...
Thank you very much, Mr. Prosecutor, and thank you to both of our panelists in this first segment in which we're exchanging our experience concerning cooperation with the ICC. And here we can see how the national judicial systems are truly committed to the work of the court. And I think that your presence here this morning is amply justified because it serves as such a good example of how we can bolster the efforts of the court in its mandate. So thank you again to both of you. And now we've kind of got a second half of this segment, if I may, and here we're going to talk more about victim reparations and assistance. And for this second half, I'm going to be asking Ms. Ruiz Verduzco and Ms. Vicente to take the floor.
Bonjour.
Voilà, merci.
There, so without any further ado, I should like now to get into this issue of victim assistance and reparations, and I shall first give the floor to Ms. Ruiz Verduzco, Executive Director of the Trust Fund for Victims. The floor is yours.
Good morning, dear Ambassador Bafai, Ambassador Labrun, distinguished excellencies. The Trust Fund for Victims appreciates your leadership and vision and sensitivity for integrating for the first time in the history of this Assembly, in the plenary of cooperation, the issue of victims. To be thorough and focused and diligent, the Assembly is compelled to segregate topics, but initiatives like this one enable states parties to identify the interconnection between all the pillars of this system. I would like to address you today on these interconnections in relation to the issue of victims. The first one is the why. As justice at the ICC is to serve victims, any measures that result in the effective, prompt, relevant investigation and prosecution of crimes ultimately will benefit the victims. We may not feel it in The Hague or see it in the press or in the media coverage, but affected communities do follow when an arrest warrant is executed or when a suspect is able to move across borders without consequences, and it matters to them. As these victims are at the heart of the Rome Statute, recalling the why must be an incentive for cooperation. Recognizing the importance of the victim-centered mandate of the Court for the purpose of cooperation has also been recognized by the Court itself in the Strategic Plan for 2026-2029. In its Goal 4, which covers cooperation, the Registry and the Trust Fund for Victims have committed to enhance engagement and communication about the victim-centered mandate of the Court, in particular about the impact of reparations and victims. This communication is not only to be rhetorical or emotional, but to be evidence-based. It includes conveying how many victims have benefited by the actions of the Court. In relation to the Trust Fund, over 78,000 in the past 5 years across 7 situations. And this communication should also tell us what is the impact that the Court is actually having. We know that victims' psychological well-being improves only by the mere process of participating in justice efforts, because victims feel recognized and they see the institutions responding to them. This increases their trust in norms and therefore strengthens the rule of law. And this is why states should cooperate. And what can states do in this respect? This year, the Committee on Budget and Finance has recommended that states participate actively to support and promote the work and the mandate of the Trust Fund for Victims, including in its reparative functions. In doing so, states parties are encouraged to raise awareness of the mission. That political cooperation can fuel judicial cooperation. Second connection. As many delegations have stated throughout the general debate, the relevance of the Rome Statute hinges on the success of the delivery of the reparative mandate of the Court, which the Trust Fund implements. This has been recognized also by the Court organs in the strategic plan under Goal 4 on cooperation, where the strategic objective says strengthen court-wide collaboration to increase the resources available for reparations for the benefit of victims. Accompanying these objectives, there is a risk register that recognizes that is of high negative impact the lack of resources that impede the delivery of reparations. The Court's reputation will be negatively impacted if we cannot deliver the reparations ordered by the judges. I wish to underscore that the total amount of liability owed to victims by persons convicted before the Court is the result of the success of the Court. As envisaged by the Rome Statute, the Court was to focus on the highest level responsible, and the Court has delivered. Individuals who hold the position of leadership have been successfully convicted for a very comprehensive list of charges, and therefore, the massive victimization that they have waged results in tens of thousands of beneficiaries. In this regard, we will do our own part. The Trust Fund, we will advance fund mobilization. The Office of the Prosecutor and the Registry must conduct financial investigation and secure assets enforced under the authority of the Presidency. And the CBF has also encouraged court organs to work collaboratively to support the Trust Fund in its fund mobilization efforts. With respect to what can states do, it is urgent that states parties take leadership in finding sustainable solutions for the lack of resources in relation to voluntary contributions, as well as in operationalizing, as the Omnibus Resolution indicates, paragraph 2D of Assembly Resolution 1.6, that speaks of resources other than assessed contributions that the Assembly may wish to provide. To close, Your Excellencies, there are elements as well in relation to cooperation that have to do with the territorial activities that we conduct, the APIC and the cooperation that territorial states can provide. I wish to respectfully present to you testimonies of victims that you can follow to ignite the will that you have. They have told us that they want peace and a prosperous future for their families, and the court can deliver these with your help. Thank you.
Merci.
Thank you very, very much, Madam Ruiz Verduzco. Now I should like to hand over to Madam Alejandra Vicente from the organization Redress. The floor is yours.
Excellencies, for allowing us to participate in this very important panel. I would like to start my intervention by reiterating again our strong condemnation on the sanctions against our colleagues in civil society and to highlight the need for state parties to cooperate in crafting strong responses to protect core staff, but also all NGOs that work with victims across all situations, ensuring that victims can access justice and reparation in this court. For victims to have effective redress, the ICC needs to be able to progress cases in all situations under its jurisdiction. And this requires cooperation also on arrest of accused persons. In this relation, we would like to highlight the following points. As the Assembly knows, civil society performs important work in this regard. Including by coordinating work on information, on suspect tracking, identifying good practices, exploring legal and ethical considerations around the tracking, arrest and surrender of suspects. Redress and FIDH, together with the Global Impunity Initiative Against Impunity, recently published a briefing paper called Ending Immunity, Ending Impunity. We formulate several recommendations for state parties to enhance cooperation in that regard, including for state parties to reaffirm their commitment to the court and fully comply with their cooperation obligations, to ensure that the Rome Statute is implemented comprehensively in national law, including clear procedures for arrest, surrender, and judicial assistance. These should include the inapplicability of immunities in relation to ICC accused persons in accordance with the Rome Statute and customary international law. It should also ensure that procedures are smooth in practice, not only in law and policy. States should also promptly domesticate and execute ICC arrest warrants and reject double standards on this matter. And finally, we recommend that states coordinate effective diplomatic responses to non-execution of arrest warrants. Once cases progress, state parties can play a key role to realize the right of victims to reparation. We highlight the importance of strengthening cooperation on asset recovery, echoing what the Trust Fund has already said, in relation to the assets of perpetrators that could be used to finance reparation. The ICC framework allows to freeze and repurpose assets of perpetrators even when those assets are not directly linked with the crimes under investigation by this court. We welcome the steps that the court has already taken to enhance its capacity in this regard, and we encourage state parties to also improve their cooperation on this matter. We encourage states to ensure proper financing of the Trust Fund for Victims. At the moment, this is clearly insufficient, and this is having a direct impact on victims even when their right to reparation has already been established by ICC chambers, such as in the Onwen case in Uganda and other cases too. For those states that are already contributing to the Trust Fund, while all contributions are extremely useful, making those contributions in a way in which they are not earmarked could be useful and would allow the Trust Fund to organize funding in the most effective way, following the needs of victims to get reparation in orders that are pending implementation. Thank you very much.
Merci beaucoup.
Thank you very, very much for that very clear and concise presentation. It's really important for shedding light on this discussion on victim assistance and reparations. And now I should like to suggest that we move on to the third aspect of this morning's discussion, which is the resettlement agreements for victims and witnesses. And I should like to invite Madam Natasha Schauder to come up to the podium, as well as Ms. Amélie Becker and Melissa Beaulieu. Could the three of you kindly take your seats?
Voilà.
Very well.
Of the court.
Thank you very much, Excellencies, dear colleagues. I'm here to tell you a story. I'm going to tell you the story of M. Now, it might be a made-up story, but I think that it actually encompasses the reality faced by many victims and witnesses that are protected by my section of the registry where I work. And I think it shows the kinds of challenges that the court is facing, particularly when people cooperate with the court, because if they do need international resettlement, they're going to need to use our services as part of the defense or witnesses for the prosecutor or victims. This is what's going to happen. Let's take the case of M, 28 years old, married, 4 children. He's young, and he lives in a context of extreme violence. And initially, he since he believed in the cause, took part in those activities, firstly on the sidelines and then more actively. And one day he saw a particularly awful incident and he decided to back out. And his former comrades saw him as a traitor and they attacked him. He lost an eye, lost part of his face, which was burned by acid. And at the end of the conflict, M decided to speak out publicly, defending values of pacifism, and he became kind of a local figure among his community. And then when the OTP started its investigations, he became a privileged witness because he had been so close to the scene of the crime. So his word was, and his testimony was really crucial. But being a witness put him and his family at risk. And this is when the section for victim and witness support comes into play, offering security measures, ensuring that he and his family are safe. Our teams, and we've got protection officers, analysts, counselors, we assess his situation, his family's situation, analyze the trauma that they've been through, and ensure that they have physical protection as well as psychological counseling and support. And we look at the way that M, through his cooperation in the judicial proceedings, has put him at risk. And then we look at tailoring the protection measures for his individuals. Now, for M, this assessment that we undertake is really important. It means that he can be inducted into the resettlement program. And remember that this is only for extremely vulnerable cases, a measure of there are lighter regimes that can be applied for less extreme cases. And once that decision has been made, then M and his family have an veritable uphill battle. To date, some 30 states, only 30 have signed the resettlement agreement with the court. Others have a kind of ad hoc agreement set up. But only half of those 30, so some 15, have actually agreed to physically welcome at-risk persons on their territory, either permanently or on a long-term basis. And this really impacts the court's ability to find long-term solutions for people who require resettlement. And in practice, how do things actually work? Well, we reach out to our state partners, signatories, or anyone open to the ad hoc resettlement regimes, and we ask them to take in M and his family. We share with the state all the information that we have, and then a decision can be made about resettling the persons. But in the meantime, M and his family need to have some kind of temporary arrangement, a safe place, but there's no possibility of integrating there, and sometimes they're shifted from place to place and time goes by. So here we are, imagine 1,000 days have gone by now. M and his family are still living in precarity, 1,000 days, and I don't take that number out of my hat. It actually corresponds, 1,000 days is very often the average length of time for these temporary solutions to be in place for sensitive cases. 1,000 days, therefore, of uncertainty, where his children can't go to normal schools, where they cannot put down roots. 1,000 days when they're still waiting for the right choice to be made. He's starting to wonder if he did the right thing, speaking as a witness for the court. 1,000 days where his family is living in precarity. 1,000 days where he feels a bit useless and wonders, I can't even get a job. I'm living as a beneficiary of the court. 1,000 days where his and his family's mental health are being jeopardized just because he decided to take part in a judicial process. Luckily, there aren't many situations like M's. For many, we can come up with a rather swift solution and find a permanent solution. They can start learning their host country's language, find work, and start getting integrated into society, including having access to social services. So it is only a few cases, and generally extreme cases, and they're usually for the most vulnerable profiles, where it's really difficult to find a host state willing to take on the case. But it's collectively that we can find solutions for these people. And that is why we would invite states parties, firstly, if they haven't yet done so, to sign the resettlement agreements in the coming months. And if they haven't done so yet, to sign that, and if there's legislation doesn't allow for that, then if the national system allows it, to agree to take in witnesses or victims on an ad hoc basis, because it's only with your support that we can actually protect the victims and witnesses that are so vital to the ICC's role, and this is part of full cooperation with the court. Thank you very much.
Many thanks. I give the floor now to Amélie Becard from the OTP. Madam co-facilitators, colleagues, eminent guests, I'm Amélie Becard, that is part of the OTP. And I work closely with the advisors of international cooperation that work closely with offices of the OTP. Today we'd like to join our voice to what Natasha has said. With the unit that protects witnesses and our international advisors, we would like to emphasize two important risks. First of all, if we cannot guarantee the safety of witnesses, we lose evidence, and our justice is therefore weakened. Second, if a witness has to wait too long to benefit from protection, they change, they stop cooperating. And when they stop cooperating, our investigations are weakened. These are two important risks that have two important consequences. The sacrifice of witnesses loses its meaning, and justice is set aside. When trust is eroded, it's not only a witness that will disappear, but often several, because witnesses in our cases are often a community. Allow me to explain why these risks are not merely theoretical, but very real and on the increase. First of all, the office addressed the largest number of protection for witnesses with the registry. Secondly, we are currently carrying out complex procedures in Africa, Europa, Latin America, Middle East, and Asia, with witnesses in more than 70 countries. In many cases, it's now no longer safe to relocate a witness within their own country. Third, our witnesses are very diverse. They have different nationalities, genders, ages, and some of them are insiders of organizations that are accused of crimes within the Rome Statute and therefore severe threats. Fourth, the registry works under strong constraints that without resettlement agreements leads to delays. Frustrated witnesses become frustrated and no longer cooperate. Due to these limits, we often send witnesses to a more advanced stage of the investigation to reduce problems, which creates bottlenecks at the time of the trial, which adds pressure to an already saturated system. These risks, which we identify, are also cover the concerns of WSG. Your support is essential. You will have understood this. Thus it is that the OTP has redoubled its efforts to bring this stake to the highest level. The institution of the group the Witness Security Group of the Forum on Cooperation and Complementarity, with the support of the registry, is the cornerstone of the office's work. This thematic group, just like others, tries to face up to the challenge of cooperation with immigration authorities, and especially with respect to financial investigations. These are essential tools. An essential cooperation and tool between the court and state parties through its in-person seminars, webinars, workshops, operationals, and joint projects with countries. This platform wants to create a community of practitioners and actors that is present here today, so as to be able to exchange on best practices on this matter and to deepen our knowledge of national legal systems. Thus it is that this foundation for dialogue with all stakeholders represents a concrete opportunity to present concretely the way in which the office can support national authorities to improve the coordination between research at all levels and reduce redoubled overlapping efforts. These coordination efforts have materialized concretely by setting up pre-consultation tools together with you so as to address requests for assistance so that states can better welcome requests for information and so as to support them in their role to the activities of the court. We also carry out and develop questionnaires that are addressed to states so they can be integrated into national frameworks, because the work of the prosecutor and the registry is not outside, it's integrated to the national system. To conclude, as was stated by Prosecutor Khan, we would invite you to join us in our efforts with the Security and Peace Unit actors. We always work closely with the registry. Thank you.
Merci beaucoup.
Many thanks, Amélie. I give the floor now to Mélissa Beaulieu. Excellencies, ladies and gentlemen, co-facilitators, esteemed colleagues, distinguished guests, we are truly grateful for your invitation to participate in this plenary on behalf of the defense this morning. The story that my colleague told you could be a script that takes place in Building E of our court for defense. Witnesses are essential for the prosecutor's office, but they're also important for the case on the side of the defense. While our role, the burden of proof, is not on our shoulders as defense, our role is to put to the test the stability and strength of evidence presented. And this is necessary and essential for justice to be presented in an equitable way. The defense teams need the means to do this, and this can be done with the participation of witnesses. They can be political opposition members, members of the government, the armed forces, or even citizens that have an important role within their communities. And if there is a message that I really want to transmit this morning, is the following. The witnesses for the defense side face the same challenges as those who are on the other side, and they also suffer the possible risk of the negative image of supporting the defense in these cases. However, ceteris paribus, these witnesses have to receive the same level of support regardless of the side of the court they're on. The fact that a person cannot benefit from proper protection, which includes resettlement where it's necessary, can dissuade witnesses to work for defense. And sometimes we're talking about essential witnesses when it comes to establishing the truth of the matter, which is part of the mandate of the court. This situation obviously undermines a fair procedure and a respect for the essential principle of equality. We also want to emphasize in this plenary dedicated to cooperation that the defense needs to face specific challenges when it comes to cooperation. The resources that we have are far more limited when you compare them to other bodies of the court, especially the OTP. We do not have, for example, a unit or a dedicated focal point that addresses cooperation. neither or rarely do we have clear, direct channels of communication with member states, which limits our participation in effective cooperation. The registry can transmit requests to states on behalf of the defense, but because of its clear neutrality, it cannot negotiate on behalf of the defense. And because of this, the requests that are made by the defense cannot be perceived or may not be perceived as having the same weight as the requests that come from the OTP. In some cases, we even face a certain resistance from states when it comes to cooperating with the defense. And obviously all of this has important consequences on the work of the defense, which is absolutely vital for the functioning of the court. Some initiatives could facilitate this cooperation and make sure that we address better the interests and particular challenges that are related to defense witnesses. For example, designating a national focal point that would be specifically dedicated to defense matters. In the light of all these challenges, we would encourage you all, member states, to sign agreements that keep in mind the specificities related to defense witnesses. International criminal law and its integrity is based on the integrity of the process, which rests, among other things, on the power that the defense has to present witnesses in conditions that guarantee their security, but also the protection of their dignity and respect for their human rights to them as well as to their families. Thank you so much. I'm the one who thanks you, dear Melissa Beaulieu, for that presentation. After having heard these three presentations, we can now hear from the delegations that would like to take the floor at the stage. And I would like to draw your attention to the following. It's 11:53. We were supposed to wrap up at noon. We're supposed to wrap up at noon. We can go over a little with the support and the flexibility of our interpreters, but obviously the condition for all this to work is for each participant now to really and truly respect the rule that we had stated at the outset. In other words, statements that do not go over 2 minutes, please. So I know it's very difficult. It's hard to not go over that limit, but I beg your forgiveness in advance if I have to interrupt after 2 minutes, because that will allow for everybody to take the floor. Otherwise, we'll have to adjourn without having heard everybody. So, let me start with the representative of Palestine, Mr. Mohammad Ayed.
And we were supposed to speak during the first segment, so please don't take my statement out of context. The State of Palestine reiterates its long-standing position that effective and comprehensive cooperation and assistance between states, parties, and the court is central to enable the court to fulfill its mandate as set out in the Rome Statute. We recall that states parties have a general obligation to cooperate fully with the court in its investigation and prosecution of crimes within its jurisdiction. The importance of cooperation cannot be emphasized any better than what is offered in decisions and findings by the chambers of this court. In this context, the State of Palestine recalls the finding by pre-trial Chamber 1 in relation to an incident of non-cooperation in the situation in the State of Palestine. In its findings, the Chamber took note that the state party invited an individual wanted by this court, and that his visit was not a surprise. Recalling that state parties are not entitled to unilaterally suspend cooperation with the court, the Chamber concluded that the state party has not offered any valid justification to its non-compliance, finding that such non-compliance prevented the court from exercising an important power and a fundamental function, namely securing the presence of the subject before the court. The Chamber also found that the state party's neglect of its substantive and procedural obligations under the statute cannot be ignored just because it has decided to leave the Rome Statute. The Chamber decided to refer the matter to the Assembly, considering the referral to the ASP as necessary to enable the Assembly to take any action it deems appropriate to ensure that state parties fulfill their obligations towards the court, and that future opportunities for arrest and surrender in this and other situations before the court are not equally lost. Therefore, we call on all states parties to cooperate with the court and ensure the execution of arrest warrants across all situations equally, including in the situation in the state of Palestine. Thank you, Ambassador.
Merci. Félicitations.
Thank you, and congratulations for respecting the 2-minute deadline. I'd give the floor now to the representative of Japan, Mr. Mizuno.
Thank you for the floor. Let me begin by expressing my gratitude to co-facilitators for your initiative and facilitation on the topic of cooperation. For the ICC to fulfill its role as a sustainable and effective judicial institution, cooperation among state parties is essential. Japan firmly believes that enhancing national capacities in criminal justice is essential for strengthening the complementary relationship between state and ICC. Japan has a long history of robust efforts in criminal justice capacity building. A cornerstone of this is UNAFE, the UN Asia and Far East Institute for the Prevention of Crime and the Treatment of Offenders, operated by Japanese Ministry of Justice and led by Ambassador Yoshimitsu Yamaguchi, a candidate for next year's election of ICC judge. UNAFE concluded a memorandum of cooperation with ICC in October 2022. A concrete example is a witness protection seminar held in 2024. UNAFE with the ICC Registries Victims and Witness section brought together prosecutors and officials from 5 Southeast Asia countries at the ICC. They shared knowledge on national realities and good practices and VWS measures. Japan plans to host these impactful seminars in 2026 as well. Mr. Co-Facilitator, Japan recognizes the importance of working alongside victims. The Trust Fund for Victims is an essential pillar of the ICC efforts. And we are committed to continue our voluntary contribution supporting numerous survivors of sexual and gender-based violence related to crimes. As this support enters its 11th year, Japan is pleased to announce a €31,000 contribution to this fund. Thank you.
Merci beaucoup. Je donne la parole.
Thank you very much. Now I should like to hand over to the representative of Italy.
Messieurs les
co-facilitators,
delegates, Italy supports the draft resolution on cooperation and its focus on strengthening operational capacities, in particular financial investigations and the digital transition of cooperation tools. Italy reaffirms its firm commitment to timely, efficient and good faith cooperation with the court. We maintain open and structured channels with the Office of the Prosecutor and the Registry and remain available for consultations to ensure clarity and swift execution of all requests. We welcome the resolution's emphasis on financial investigation and asset tracing. Italy has invested in developing advanced capacities in this field through the Guardia di Finanza. Our system allows sophisticated tracing of complex financial flows, identification of assets hidden behind corporate structures, rapid freezing and seizure of proceeds. This commitment is exemplified by the recent training program offered to the Office of the Prosecutor, an e-learning cycle followed by a specialized residential course in Rome for investigators. This initiative illustrates Italy's determination to reinforce the court's capacity to address the financial structures underpinning serious crimes. We stand ready to continue this cooperation, in particular with the newly established Financial Investigation Unit, whose creation we welcome. Italy also brings extensive experience in joint investigation teams coordinated through Europol and Eurojust, which have proven essential. We are ready to explore how similar models adapted to the Rome Statute system could further assist the court's investigative work. We remain engaged on the diplomatic front, ensuring implementation of the Agreement on Privileges and Immunities, including for former elected officials. We welcome the court's concept note on protection as cooperation and look forward to contributing to this work.
Je vous remercie.
Merci.
Merci bien.
Thank you. Thank you very much. Now I should like to hand over to the representative of Finland. Representative Autio, you have the floor.
Distinguished chairpersons, Finland thanks the co-facilitators on cooperation, Senegal and France, for chairing this plenary session. We thank the panelists for providing their valuable insights on the forms of support required from states parties. The ICC's ability to fulfill its mandate is dependent on states' genuine and sustained cooperation. Every arrest executed, every piece of evidence or information shared, and every witness protected strengthens the court. Cooperation agreements between states parties and the court are important instruments in enabling the ICC to implement its mandate. We call on all states parties to ratify the agreement on the privileges and immunities of the ICC. The APIC is a crucial instrument for protecting the court, its elected officials and its staff. In addition to formal cooperation, providing adequate resources to the court and upholding its independence are key, especially in today's context of political pressure, threats and attacks, including sanctions. Distinguished chairpersons, as we work to support and safeguard the ICC, we must extend our efforts to protecting those who collaborate with it, including human rights defenders and civil society. The work of the Trust Fund for Victims is key in redressing the harm suffered by victims and survivors. Finland is a long-standing regular supporter of the Trust Fund, and we call on others to join us. This year, our voluntary contribution will assist the victims of sexual and gender-based violence in the Central African Republic and help launch the landmark reparations program for the victims in the Ongwen case. In closing, let us reaffirm that cooperation is not optional. It is the lifeline of the Rome Statute system. Finland continues to stand firmly with the court. Thank you, chairpersons.
Merci, Madame.
Thank you very much. Now it's my pleasure to hand over to Venezuela. Madame Martinez, you have the floor.
Gracias, señor facilitador.
Thank you very much, dear facilitator, for giving me the floor. In the context that the court is currently facing, among other questions, the issue of threats and the application of unilateral coercive measures constitute a major hindrance to the court's work. And it affects not only the institutions, but also states parties of the Assembly, and therefore to their peoples. And the most recent resolution on this topic says that any unilateral coercive measure that is imposed is necessarily counter to the provisions of the International Charter of Human Rights and therefore counter to customary international law and has negative effects. And the resolution therefore says that such measures are unlawful, and that's why Venezuela would like to lend its continued support to any condemnation against these unilateral coercive measures, because unfortunately they affect whole peoples and it's important for many countries to stand up to these measures. And a clear example is the position taken by many Western countries that have abstained systematically or not voted in any condemnatory resolutions in the Council of Human Rights. And therefore we regret the unprecedented intimidation leveled at the court, and we think that we should act determinedly to counter such unlawful measures. In the case of Venezuela, the damage caused by illegal sanctions when it comes to human rights have become crimes against humanity against the Venezuelan people. And this is what we see in the situation Venezuela 2, which is currently before the court. We call on all member states to reiterate their commitment and to stand up against these unilateral coercive measures. If we're going to foster true cooperation, then it needs to be a holistic approach and fighting the evils that we're all facing. Thank you. Thank you. Now I should like to hand over to the representative of Bolivia. Madame Moreno, you have the floor.
Señor co-facilitador.
Thank you, co-facilitator, for giving me the floor. We would like to welcome the work done on cooperation by the court and its organs. The cooperation undertaken as a part of the Rome Statute is a pillar of the court's work. We understand the importance of cooperation to ensure complementarity and universality. Under the Rome Statute, effective cooperation between states and the court is of vital importance if the court is going to deliver on its mandate without hindrance. We welcome the technological and instrumental steps forward, such as the toolkit, for example, and also the procedures for resettling and ensuring the safety and security of witnesses and victims before the court. We think that it's important for the court to have the wherewithal in order to fulfill this, and Bolivia would like to also welcome the work done by the principals of the court. But we feel that the most serious crimes before international justice must not go unpunished, and further cooperation is necessary. Allow me to mention Article 86 of the Rome Statute, which says that the states parties have an obligation to fully cooperate with the court. When it comes to complementarity, we underscore the importance of states parties in transposing Rome Statute law into national law. We would like to reiterate our firm commitment to complementarity and cooperation with the court, and express our firm commitment to the unhindered operations of the court in the name of international justice. Thank you. Thank you very much. Now I should like to hand over to the representative of Belgium. Mr. Anar, you have the floor.
Madame et Monsieur les co-facilitateurs, merci de nous accorder une...
Thank you again, dear co-facilitators, for giving us the floor again, and thank you very much for the various very instructive presentations that we've just had, underscoring the issues that the core faces when it comes to cooperation. First of all, let us record that signing and rolling out these agreements is of vital importance. They are truly a key part of the court's work vis-à-vis victims. They are not just and it's important for the court to be able to undertake its work swiftly. When it comes to reparations for victims, over and above the voluntary contributions made to the TFV, Belgium has also got a special provision in its cooperation law enabling for the seizure and confiscation of assets, so that this can contribute to the payment of any fines as stipulated by the court. When it comes to arresting suspects at large, Belgium again has noticed that we've had good recourse to the services of our Central Cooperation Authority, which is in direct contact with the court. It means that we can centralize information, decision-making, swiftly contact the court, and it gives us the wherewithal to take swift action. Allow me finally to say a word on complementarity. We encourage all states parties and non-states parties to sign agreements with The Hague, so that states parties can assume their primary responsibility in executing arrest warrants in the case of these most heinous of crimes. Thank you. Thank you very much. Now I should like to hand the floor to the representative of Slovenia.
Merci, Monsieur co-facilitator.
Thank you, dear co-facilitator.
On cooperation, and thanks both co-facilitators for your endeavors on this topic of paramount importance. I would also like to thank the panelists for their important contribution and reminding us that our underlying goal is delivering justice to victims. The court cannot fulfill its mandate without full cooperation and support of member states. This in particular implies execution of arrest warrants, relocation and protection of witnesses, enforcement of sentences, and granting privileges and immunities to the court and its members. Any pressure on the court and its officials is unacceptable and should be fully rejected. Imposing sanctions on those who are pursuing justice and fulfilling goals of this court are contrary to the fundamental principles of international law and objectives of this Assembly. We must be therefore crystal clear on rejecting such measures and offer our full support to the court, judges, elected officials and its staff, as well as all those cooperating with the court. Mr. Co-Facilitator, we would also like to stress the primary responsibility for investigation and prosecution of international crimes lies with Member States. In this regard, we would like to recall the recently adopted Ljubljana The Hague Convention on International Cooperation and Prosecution of International Crimes. And I would like to call on all states to consider becoming parties to this important convention with a view to building on our joint endeavors to close the immunity gap. Slovenia reaffirms its full commitment to the court and justice to victims. I thank you.
Merci beaucoup.
Thank you very much. Now I should like to hand over to Sierra Leone. You have the floor.
Thank you, Mr. Co-Facilitator. Sierra Leone thanks the co-facilitator France and Senegal and take this opportunity to also thank the panelists for their important and insightful briefings. Sierra Leone reaffirms that cooperation remains central to the credibility, resilience, and legitimacy of the International Criminal Court. The court's ability to fulfill its mandate and deliver justice to victims depends entirely on the sustained and unconditional support of state parties. In our capacities as Vice President of the Assembly of State Parties, coordinator of the African group of state parties in New York, and co-focal point for the informal ICC caucus at the Council, Sierra Leone is committed to fostering diplomatic and political solidarity. Through constructive dialogue and proactive outreach, we will continue to uphold the court's independence and institutional integrity. We hold the conviction that cooperation is not merely a treaty obligation, but serves as the cornerstone of the court's efficacy and sustainability. My delegation proposes 3 areas for strong support, concluding relocation agreement for witnesses and victims to protect those who risk their safety for justice, increasing sustained contributions to the Trust Fund for Victims, to restore communities and deliver meaningful justice, and enhance coordination to arrest suspects to end impunity. Thank you very much.
Merci beaucoup.
Thank you very much. Now I should like to hand over to the Ambassador of Guatemala. You have the floor. Thank you very much, co-facilitators and all of your teams, for all of your work this year. In the general debate, Guatemala talked about cooperation as the central axis of the court's work, and the lack of local cooperation is one aspect of this. They go hand in hand, and yet this is tightly connected with complementarity and also universality. Although we all aspire to universality, strengthening the Rome Statute isn't just about numbers. It's got to be applied, it's got to work, it's got to be rolled out fully. And that is why you've got to have implementing legislation, you've got to sign the APIC, and look at all mechanisms for cooperation. And that is why we need to have appropriate tools, be they legal, technical, logistical, so as to operationalize our cooperation with the court. I do think we need inclusive discussions, be involved in facilitation so that we can ensure vital cooperation with all the different organisms. Because remember, this is multidimensional, and we want to thank you not only for the Bureau report, which talks about the various different ways in which we can heighten cooperation, but also gave everybody a chance to hear the different experiences of coefficients. And then it comes down to political will. Some of the milestones that we've had have been the fruit of successful cooperation with the court, and we want to commend Germany for ensuring the surrender of El-Hishri for crimes against humanity and war crimes. And we want to reiterate our continued support for the court and make sure that the outstanding arrest warrants can then be implemented. Thank you very much. Thank you. And now I should like to hand over to the representative of the Central African Republic. You have the floor.
Bien, Monsieur le Président, chers sommité.
Dear Chair, co-facilitators, I am taking the floor on behalf of the Central African Republic. And in that capacity, I should like, first of all, to reiterate the Central African Republic's support to the International Criminal Court in this very turbulent juncture. The court that the current court is currently going through with the coercive measures leveled against it. As concerned cooperation per se, the Central African Republic, through the surrender of the Ongwen and the LRA leaders, I think has been proven that with the Alfred Yekatom and others, this means that the local authorities have had to have access to evidence, and we feel that this attests to the good cooperation between our authorities and the ICC. Such good cooperation heightens complementarity and boosts the credibility of the ICC. And when it comes to victim protection and witness protection, as we heard before, justice moves forward slowly, but for the victims, it can be a very long process indeed. Thank you very much. Thank you very much. Now, Spain has requested the floor. I am going to ask that this be the final state party to take the floor this morning. Thank you very much to the dear co-facilitators from Senegal and France. Spain welcomes the inclusion of this segment in our agenda and reaffirms its commitment to fully cooperate with the court. States parties need to cooperate, and that is why the recent agreement with my country concerning the amendment and cooperation are a welcome step forward. Could the speaker kindly slow down? The interpreters do not have a copy of your speech. Thank you. The full and timely cooperation with the court boosts the credibility of the International Criminal Court and therefore international justice for one and all. Thank you.
Je vous remercie.
Thank you very much. This brings us to the end of the list of states parties who have requested the floor. And now I should like to hand over to the Coalition for the ICC, which will be the final speaker on this morning's list. Thank you. Thank you very much, Mr. Co-Facilitator.
Soif, President of the FIDH, the International Federation for Human Rights, and I'm honored to speak on behalf of the CICC, the Coalition for the International Criminal Court. Cooperation is the backbone of the Rome Statute system. When it's weakened, it is victims who feel the consequences. Each failed arrest denies them truth, accountability and reparations. The coalition urged states to respect their legal obligations and take practical steps to strengthen cooperation. We have seen it work recently. Just days ago, Germany surrendered Libyan suspect El-Hishri, and earlier this year, the Philippines cooperated in surrendering former President Duterte. CICC strongly welcomes these developments. For many victims and survivors, this has restored a measure of hope and reinforced their belief that the system can work when states act with resolve. But we have also seen serious failures, with 3 findings of non-compliance, two of which were referred to this ASP. This highlighted the need for concrete action to ensure cooperation. First, if any ICC fugitive is in your territory, it's your legal duty as the informant's arm of the court to arrest and transfer them to the court. Second, strengthen all aspects of operational cooperation, including through prompt response to requests for evidence, information and access, the relocation of witnesses, support for defense and victims' counsel, and entering voluntary cooperation agreements. Third, strengthen national preparedness. All states parties should carry out simulation exercises on how an ICC arrest or surrender would happen in real time. These exercises identify gaps in domestic legislation and ensure that police, border officials and justice actors know their responsibilities. Finally, publicly reaffirm your commitment to full cooperation. When states affirm their full cooperation with the court, reject immunity claims and emphasize equality before the law, they reinforce the principle that no person is above justice, setting the tone for national authorities. In contrast, inconsistent or ambiguous statements create the impression that the law is selective. Excellencies, victims in all situations have the same right to justice. Cooperation is how two states make that right.
Thank you, says the chair.
Thank you.
Merci. Merci beaucoup.
Thank you. This brings us to the end of the second segment. It's been a very rich discussion, and I want to thank each and every one of you who took the floor for making this a particularly rich discussion. Thanks also to all of you who showed such discipline with our timekeeping. So thank you. And thank you for everyone who agreed to be with us this morning. And now I'd like to hand over to Ramatoulaye for her concluding remarks. Thank you, dear François, Excellencies, ladies and gentlemen, dear experts, dear panelists. Allow me, first of all, to express, in my own capacity and also for Ambassador Alabrune, all of our gratitude for the quality of your statements that we've followed with close attention and great interest. Your statements and contributions have enriched our understanding of everything associated with this vital issue of cooperation with the ICC. Our discussions show that cooperation really is the cornerstone of the court's action. And in this context of threats and sanctions against the court, it's as important as ever to ensure that the court remains resilient and independent. It needs to be expressed through political support, because that will support our elected officials and staff, through operational commitment, with arrests for those at large, executing judicial decisions, and finally through human solidarity, which we can see through the Trust Fund for Victims and for relocation agreements for victims and witnesses. These responsibilities entail real challenges, but they can be addressed thanks to this heightened synergy between states parties, non-states parties, and international organizations, be they local, regional, or global. And it's by consolidating these instruments that we'll be able to strengthen the institution, but also offer a vision of universal justice for victims and human dignity. Before we leave, I just wanted to thank all of the interpreters, without whom we would not have been able to continue these discussions in the various different languages of the court. I also want to thank each and every person who participated in this morning's plenary on cooperation, and I wish you every success as you continue your work in the 24th session of the ASP. Thank you.